Buppert from the Southern Environmental Law Center. I'm going to talk about a couple remaining cases that are out there. And like Joe said, I've never been involved in an effort that involves so many different angles to get at a project and trying to stop a project like this. It's really quite remarkable. One of the big problems with the process is we don't ever have the opportunity to ask, at FERC, for example, ask any questions of Dominion or Duke Energy, the people putting this project forward. And so last year we used a proceeding at the State Corporation Commission, which is the Virginia entity that sets our utility rates, to ask questions about the pipeline. And some of the answers were really pretty terrific. So we asked Dominion if they had studied whether or not they need the pipeline to meet their power obligations. They said no. That was very frank. We were able to collect a lot of other information in that process that we then could put into the FERC docket, as Ben mentioned. We put a lot of evidence in there about whether or not this project is needed. One of the most interesting things we learned at the State Corporation Commission is that Dominion wants to use its capacity on the Atlantic Coast Pipeline to run its existing power plants, or to fuel its existing power plants. But all of those power plants already have contracts on other pipelines, and those contracts are anywhere from 17 to 20 years into the future. So, and the gas that's being transported under those existing contracts is less expensive because it's moving on an older infrastructure and it costs less to move gas on that infrastructure. The Atlantic Coast Pipeline is a lot more expensive. So that, in my mind, it raises the question, well, why does Dominion want to build the Atlantic Coast Pipeline? Why do they own 20% of the capacity? And I think we started to get part of that story over the last few months when Dominion's plans for expanding the pipeline into South Carolina started to come to light. At the end of the day, this will be a very lucrative project for the company. Owning that capacity, even though they told FERC they want it for their power plants, we know they don't need it for their power plants. They can sell that capacity other places, maybe in South Carolina. There's a lawsuit against, one of the lawsuits for the Atlantic Coast Pipeline is against the Forest Service. As Ben said, the Forest Service folks at the local level were very committed to asking questions about this project. If you were following that, you remember last May, as late as last May, Clyde Thompson said, if you don't get us this information about steep slopes, we can't approve this project. And Dominion apparently really freaked out. It wasn't when that letter went into the docket. Shortly after that, the Forest Service changed direction, did a 180, issued a draft approval for the project in the middle of the summer last year, and then they've since approved the project and granted the special use permit. The result is the record on which the litigation will be based is pretty interesting because it includes a lot of detailed questions from staff, a lot of statements like Clyde's that without this information we can't approve the project, and then an abrupt change. We think that's the result of political pressure. Some people at the Forest Service have told us that, and we think when we get that record, that political pressure is going to be part of the, in the record and part of the story. And that will make for, I think, interesting brief writing for us to point that out to the court. We've also sued the Fish and Wildlife Service over something called a biological opinion that allows Dominion that allows the project to harm endangered species. Like the Fire Service, that agency was pretty skeptical of this project, and we think there are flaws in that biological opinion that make it vulnerable. If that case is successful, it has an interesting, there's an interesting result, because every other federal permit depends on that biological opinion being effective. So there will be a ripple effect on all the other federal permits for the project if we win that case. And then the final case to mention is one against the Park Service. And this case is very interesting. It's less about process. It's not about process, in fact. It's about whether or not the Park Service has the legal authority to grant a right-of-way for the pipeline to drill under the Blue Ridge Parkway. We think there's a pretty good argument that the Park Service doesn't have that authority, even though they've granted the right-of-way. And if we're right, if we win that case, it can't be fixed with more process. Dominion would have to go to Congress and have a law passed that would allow it to get drilled through the Blue Ridge Parkway. That's what you have to do if you want to build an interstate natural gas pipeline through any other national park. That's what you have to do. You have to go to Congress and get approval. The Blue Ridge Parkway has used some language in the statute that created the parkway to say that, well, in this case, we don't need to do that. We think they're wrong. Like all of these cases, it's going to depend on what judges hear the case, but we think the argument, it's a good argument, and if it's right, it will have a pretty significant impact on this project. I think we have a little bit of time left, and I think I'm supposed to open it up to questions. Lou, do you want to?
Yeah, I'll be the. What time is it, by the way, so I keep track of it?
2:17.
Okay, great. Yeah,